One question we get from clients and potential clients is, how do I buy out my business partner? Either we're not getting along anymore and they need to go, or I need to go, or sometimes it is amicable and it's simply a matter of, hey, my partner is done with this business and wants to get out. What do I need to do now? Hey there, this is attorney Sarah Holmes of Holmes Business Law P.C. We are a business and trademark law firm that also provides general counsel subscription services to business owners. All right, so your first step in a partnership buyout is always pull out whatever document governs your relationship. That means if you have an LLC together, that document will typically be your operating agreement. If you have a corporation together, that document would typically be your shareholder agreement. If you don't have any legal entity, well, that's probably an issue in the first place and not good, but maybe you just have a general partnership agreement on paper, okay? So your first order of business is to always pull out the paperwork that governs the relationship. If that paperwork has been signed by all the members, all the partners, you're good. That is the document in play, unless there were like later amendments or things added to it, and that's the document you should go by. Now, the big problem comes when you don't have a document or you have an unsigned document. Now what you have to do is go by the state's default rules that govern the type of entity you have. So at least in Pennsylvania, there are state statutes that say, hey, in the event there's an LLC and a dispute among the members, this is how things would be decided. That is probably not going to be in your favor. It's something that, this is why you want to have proper written documents in the first place, is that so you can control how that goes. Same thing if you have a corporation and you have no shareholder agreement. By that point, you probably have much larger problems because you're using a corporation and not observing some of the formalities like having a shareholder agreement. But the fact is you now have to go by the state default rules. So now at this point, you should either look through the written documents yourself, or now it's time to call legal counsel and say, hey, I have this written document. I'm not sure how to interpret it. So what's my next step in buying out my partner? If you don't have the written document, your next step is to call the lawyer and say, hey, I don't have the document. What does the state tell me I have to do in this instance? All right, so now that we've gotten to that point, typical provisions you would have if these documents were done properly in your operating agreement would be often provisions about if someone wants to leave voluntarily, how are you coming up with a number to buy the person out? Is that person vested in all of their membership interest? Meaning maybe you had a situation where this business belonged to you for a couple years and you later brought in a key employee and gave them some equity. Maybe you had some vesting provisions in there that said, hey, I'm gonna give you 20% of this business, but you're not gonna get it all up front. You're gonna get it over a period of 5 years, right? So if that person wants a buyout before that 5 years is up, you shouldn't owe them the full amount that's in your operating agreement. In fact, you would owe them the amount of money that they have in the vested shares. Your operating agreement should also have a formula by which you're going to calculate what someone is owed. Ideally, it's either a multiple of earnings, of profits, or some type of formula you came up with. There may be language in there that the parties agree to go to their normal accountant who's willing to put a number on the business. And then short of that, your other option is to go get a formal valuation done. Now, a formal valuation by an actual firm that does these all the time can be very, very expensive, like tens of thousands of dollars, depending on your industry and how complicated your business is. There may be some valuation services out there that are willing to do these as part of a partnership dispute to figure out what you'd have to pay a partner. Because what you're going to pay a partner is often different than what you'd have to pay or what you could expect, for example, a third-party buyer or maybe even another investor to come in and pay for the same shares of the business. So you're gonna have to figure out what's the number. And to figure out the number, you first go to your documents to see if you and your partner specified a formula. All right, once that's done, you need someone to draw up the paperwork. You also have to see what types of conditions are gonna come with an exit. For example, most people would never be able to leave a business without signing a non-compete or being bound to some type of rules about using client lists, not being able to use IP of the business they were formerly an owner of, because you can't take those things with you and then go compete against the former business you owned. Most business partners would not allow something like that. So in a nutshell, if you want to get out of a partnership or you have to buy out a partner, those would be different steps to take. Number one is always pull your documents, see what those say. Number two, if you don't have documents, you have to go by state default rules. And then number three, figure out where's the formula for how much to pay the partner to get out, if anything. Sometimes there are punitive provisions in an operating agreement that say if the partner is leaving for cause. For example, they were doing bad things in the business. Maybe they're embezzling money. Maybe they were careless or negligent. Maybe you don't owe them anything. However, that would have to be in the operating agreement. That's just not an automatic rule and, oh, my partner doesn't get anything, they just have to leave. No, what's gonna happen in that circumstance is your partner's gonna lawyer up and you're gonna wind up litigating this in court and figuring out what you have to pay them at the end of the day. So this is why having proper documents in place from the very beginning is really, really critical. So of course, if you have questions about a partnership or you need the documents done or interpreted because you're now in a buyout situation, feel free to reach out to our office. Our number is 215-482-0285. Thanks.